Tony, are you ready to get started?
Yes, Judge.
All righty, let's go on the record on DC 215659. Prestonwood Pond versus Waite Capital Inc. et al. Counsel, make your appearances.
Good afternoon, Your Honor. John Hoffman on behalf of the movants.
Your Honor, Chris Albert on behalf of Plaintiff Prestonwood Pond, LLC.
All right, so you can probably guess what my question is here. So I've read the briefing, and there's obviously an issue here involving whether or not some of these parties that are moving for summary judgments were, I guess, sublessees of the lessee in this case. That to me, it seems like it'd probably at least be a fact issue whether or not they're sublessees. And so that's kind of what I'm most focused on. But if there's other things you want to talk about, we can.
May I proceed, Your Honor?
Sure.
And I'll get straight to your question. There is no evidence and nothing outside of evidence I'm aware of that shows that they are sublessees or ever have been sublessees. And I believe if you look at the declaration of the plaintiff or of the representative of plaintiff, I think he acknowledges there was never any kind of sublessee agreement or any kind of acknowledgement of those movements as being sublessees. So I'll address that question right off the bat. And just to step back for a minute, Your Honors, you know, this case stems from a lease agreement entered into by Waite Capital Inc. and the plaintiff. I'll note we did not file a motion for summary judgment on behalf of Waite Capital Inc. I'll readily acknowledge there are fact issues related to the claim for breach of contract against Waite Capital Inc. We're more than happy to litigate that case, but it is not before us.
Isn't there evidence in the record, at least I know there is in the argument of the briefing, is that a lot of these other entities that are moving for summary judgment, I don't remember if they had their corporate headquarters or were in that spot, but they did quite a bit of work activity within that location.
I'm not aware of any evidence in the record that reflects that those four movements were ever on the premises. Now, I do acknowledge there are Secretary of State records, I believe, for some of the movements that reflect that for a time they had that address reflected with the Secretary of State records. But Your Honor, I don't believe that reflects or shows that they were subtenants or even that they used the premises for any purpose. I'll readily acknowledge, and you'll see in the Secretary of State records, that there are multiple entities in which multiple individuals appear to be owners, including Daniel Waite, the only individual defendant. He has an ownership interest in these various entities, and it appears that he used Waite Capital Inc. as a means of managing these different entities, and that's maybe in part how that premises was used. But I don't see anything in the record, and I'm not aware of any evidence at all that's been produced during the course of discovery that reflects that these different individuals and entities that are movements here actually use the premises. Now, I'll note Daniel Waite is an individual named defendant. He is also an officer and director of Waite Capital Inc., who is the party to the lease agreement. So, of course, I assume, there's no evidence in the record that reflects it, but I assume that working forward on behalf of and as an officer of Waite Capital Inc., he would have been on the premises. That does not mean that these other entities were subtenants. That does not mean that these other entities made use of the premises. And I'll get into some argument in a minute that even if they did, which there is no evidence that they did, even if they did, that's not sufficient to establish the claims alleged by the plaintiff against these different movements. So, Your Honor, our position is very simple. This is a leverage play. They've sued anyone and everyone they could think of that has some tangential relationship to Daniel Waite and this other entity in an effort to leverage in this case. But the core of the case is Waite Capital Inc. against plaintiff. And that's the reason why you don't see a motion for summary judgment on that, is because I readily acknowledge there are fact issues there in relation to that claim. And I think it's very notable. Plaintiff has not served a single discovery request on any of the movements, let alone on Wake Capital Inc. This is an effort to leverage through an assertion of claims that are not properly pled and for which there is no evidence. And Your Honor, to get into each claim briefly, I want to just give you a very simple overview of the evidence that is before the court. First, we have a declaration of Michael Aguilar, a representative of the plaintiff. That declaration does not address any of the claims alleged by movements. What it does is it proves up a lease agreement between the plaintiff and Wake Capital Inc. So it really doesn't provide evidence as to the claims at issue today. Exhibit 1 to that declaration is the lease agreement. Again, it speaks to the agreement between Wake Capital Inc. and plaintiff. It does not speak to the claims against the defendants who are movements today. Exhibit 2, we mentioned briefly the Secretary of State records for these different entities. Those Secretary of State records reflect the existence of these different entities. It reflects the names of the members or manager or the governing parties to those various entities, as it was reflected at the time those documents were printed. Does nothing more than that. And I don't see how those records could in any way impact the claims before us today. There is a notice of default as Exhibit 3 to the declaration. That notice of default postdates all of the claims being sought here. And I should point out in relation to the notice of default, Your Honor, I think it's important to note that the plaintiff is seeking compensation for rent under the agreement. In other words, after Wake Capital Inc. left the premises and stopped making payments allegedly under the lease, that is the rent that is being sought prior to them mitigating damages and putting someone else on the premises. That rent, there is nothing before you. I don't even see an argument in the record that these movements were on the premises, benefiting from the premises during that time frame after Wake Capital Inc. left the premises. I think they probably acknowledge that. In fact, if you look at the declaration of Michael Aguilar, he says, under the cover of darkness, I'm not quite sure what that means or what that's a reference to, but under the cover of darkness, the tenant left. And they're asking for a recovery of lease payments during the contractual term after that time frame. Those are not amounts that can be sought by virtue of an unjust enrichment or by virtue of a quantum merit, very simply because clearly they were not beneficiaries of that premises in any way, shape, or form during the period in question in which they seek damages. So I think it's important to note that because they have to show some receipt of goods, services, or otherwise in order to prove an unjust enrichment or a quantum merit claim. And they're seeking it during a very specified time frame after the defendant, Wake Capital Inc., who was a tenant under the lease, left. There's no allegation, let alone evidence, that any of these movements were on the premises or received any benefit, services, or otherwise during that time frame. So just want to point that out. Exhibit 4 to the declaration are top 3 checks allegedly paid to Prestonwood Pond. Again, I don't understand how those checks have any relevance. They do not establish any of the elements of the claims before the court. Exhibit 5 to the declarations is Secretary of State records for a third-party entity that is not a party to this case, and Facebook's records from a third-party entity. And what it seems to me is plaintiff is saying, hey, look, Judge, we can't really prove our claims in this case, but look at the weird, bad stuff that this guy is doing outside of this case. No relevance whatsoever. I don't know anything about it. All I know is that they seemingly attach it to the evidence here in an effort to suggest that this is the kind of activity that these movements engage in. But it is not summary judgment evidence. Your Honor, with respect to unjust enrichment specifically, we have raised the allegation that they do not have evidence to support any of the 4 elements, which are plaintiff rendered valuable services or furnished valuable materials. The services or materials were provided to defendant. Defendant accepted those services or materials. and the defendant was reasonably notified that the plaintiff expected to be paid by defendant for the services and materials. Your Honor, there's no evidence before the court of any of those four elements. Now, again, it's important to remember the time frame in which they're seeking damages is a time frame after everyone was gone from the premises, right? There is no evidence before the court that any of the movements were on the premises, used the premises, or in any way benefited from the premises during that time frame. There is no evidence before the court that plaintiff intentionally provided the premises in any way, shape, or form to the defendants. In fact, to the contrary, the declaration shows that he says that plaintiff never accepted them as subtenants. But then he falls short of even saying they were on the property. Well, we have a declaration here. He makes no effort in that declaration to say that they actually utilized the premises. There's no evidence before the court that they did. Finally, there's no proof that the defendants accepted the use of the premises or that the defendants, the movements here, were notified of some expectation of payment. I just don't see it, Your Honor. And if you look at the one case they rely on that seems to be even tangentially related, it's easily distinguishable. In the Blevins case, there was a contract for sale of land. The buyer of the land put down a down payment, and in the interim, before the sale of the land was finalized, the buyer went on the property and started utilizing the property. In that case, there was a contract between the parties at issue. There was a clear expectation of use. There was a clear benefit of use of that land. Well, there was a clouded title apparently, and so the contract fell through. The buyer, after the contract fell through, continued utilizing and benefiting from the land. Your Honor, that is not the case here. There was a clear benefit in use of the land by the defendant in Blevins. There was a contract in place where the parties intended to provide these various benefits. In this case, you do not see any contract between the parties. You do not see any communication between the movement and the plaintiff. You do not see anything that indicates any expectation by either the plaintiff or the movements of payment from one or the other, or for the provision of that premises for the use of the movements. So, Your Honor, there's simply no evidence and no case law to support what is presented here is a curious argument of unjust enrichment. At best, what they have is a breach of contract against the tenant to the lease. If they want to argue that these parties were improperly on the property, which again, I see no evidence of, but if they want to argue that at trial, that's a claim for breach of contract against Wake Capital Inc. Your Honor, with respect to quantum merit, again, we raised an issue with respect to each of the elements of that claim. The plaintiff rendered valuable services and furnished those to the movements, that they were provided to the movements, those materials or services, that the movements accepted those materials or services, or that the movements were reasonably notified. Again, very similar to quantum merit, you just do not, or very similar to the unjust enrichment, you just do not see any evidence showing the parties exchange any correspondence in that regard. There was an expectation of payment. There was a provision of the land for use by the movements. It just does not exist. I'll again reference the case relied upon by the
right, I got it. Let me hear a response.
Thank you. So, Your Honor, as to the subleasing issue, I think the evidence is sufficient for no evidence motions for summary judgment that by their own filings and representations to the Texas Secretary of State, they were using this address not for their company headquarters as well as for their registered agent address. That is enough. That's all. That's what we've shown. That's all we need to show. that they were in fact using and benefiting from this. But to get to opposing counsel's argument about this specific time frame on which we are looking to, I guess, receive compensation from the defendant for the breach of the lease, for leaving in the under the dark of night, which that's what they did. Middle of the night they moved out. But the reason you get there is because what we have, Your Honor, is this Daniel Waite creates a pool of companies, all of which from the get-go are undercapitalized, evidenced by each of the two entities of Waite Inc. and Waite LLC have tax forfeitures within a year of signing this lease. And there's further evidence, Your Honor, attached to our response that they're just pooling whatever assets they have to scramble to make payments here. That includes Mr. Waite paying individually. That includes American Construction paying for part of the rent. So there's further evidence that they were in fact using it, but it's also evidence that you've got this group of entities whose corporate formalities really aren't being, they're not being actually used as corporations. They're really just used as for Waite's purposes. And so whatever pocket he needs to pull money out of to pay for, that's what he does. The lease is clear that at any point if they have another entity that's doing business out of that same spot, they need to notify the landlord. They did not do it. But it all comes back to, Judge, that these are all of the entities are a joint enterprise it's the alter ego of Daniel Waite. And so whether it's American Construction, the quantum Merowit unjust enrichment argument is as to all entities and Daniel Waite, because they all are essentially Daniel Waite. That's how the argument comes down, Your Honor.
Your Honor, may I briefly address each of those?
Sure.
So first off, there are, if you take 10 minutes and analyze Secretary of State records, what you will see is there are thousands upon thousands of entities that list as their registered agent or their principal place of business a registered agent's address. Many of those registered agents are corporate entities such as CT Corp and many others that provide registered agent services. What opposing counsel is suggesting is that a landlord could bring a claim for breach of a lease agreement or quantum merit or unjust enrichment based merely on the fact that an entity lists a registered agent address in the Secretary of State's records. That's preposterous. I mean, that's just not the way the law works. And there's a reason why he can't find a single case to show you that supports that argument, because it doesn't exist.
Well, let me ask Mr. Albert this. So what concerns me is that, I mean, to find an alter ego type, make an alter ego type claim, there's extensive evidence that would need to be shown. It doesn't seem like, and sometimes cases don't justify the expense to do the discovery, but it doesn't seem like you have any evidence other than kind of speculation, and you may be right, that these companies are alter egos of each other, other than you have the Secretary of State records. And so, and there isn't any case law, I guess, on the issue of if you use a particular address, does that make you, I kind of feel like you could probably make this claim. I just don't know that you have the evidence in the record to support it.
And I apologize, Your Honor.
Go ahead.
If we were at trial, I guess let me say it another way. The standard for the motion that we're in front of the court for right now is that I need to demonstrate a scintilla of evidence. I believe I've done that in two ways, showing the alter ego. I think I have a scintilla of evidence by showing that we had multiple entities paying for rent for another entity. One. Two, and that by itself, I think, is a scintilla of evidence that gets me past this motion for no evidence MSJ. That's some evidence. Then beyond that, we also have this headquarters and registered agent. That's yet another piece of evidence that I can use. Granted, Your Honor, we need to do discovery so I can get additional evidence to meet my burden at trial. But for purposes of a no evidence motion for summary judgment, I think we've met it.
Your Honor.
I guess focusing on, so which companies actually helped pay this rent? I know that Mr. Waite individually did, right?
Mr. Waite individually, American Construction, and Healthco LLC.
And which were the entities that actually, there's four, I think, summary judgments. Was it those three entities that moved for summary judgment? Were three of them?
So Waite Capital LLC, Healthy Co., Daniel Waite individually, and American Construction all moved for summary judgment. So there are four movements, Your Honor.
So Waite Capital LLC never paid rent.
Well, I'm not, if it ever did, I'm not aware of it, and I don't see any evidence in the record of it.
I mean, this is, at this point, I'm going to deny summary judgment as the Waite individually, American Construction, and Healthco. I'll grant summary judgment as the Waite Capital LLC.
Your Honor, we haven't addressed the fraud issue against Daniel Waite individually. May I speak to that very briefly?
Sure.
It's the one claim, and I apologize, I would have referenced it earlier. It's the one claim that doesn't overlap between the four movements.
Okay.
And it's Daniel Waite individually is the only claim that the plaintiff has alleged fraud against. And so what you'll notice, Your Honor, if you just glance at their arguments as to fraud, they do not cite evidence even once for their fraud claim against Daniel Waite individually. And as you know, fraud is a steep hill to climb. They got to show a representation. They got to show the representation was relied upon. Well, they got to show the representation was false, that it was relied upon, damage, etc. You don't see a single representation asserted in the response to the no evidence motion for summary judgment as to Daniel Waite individually. And the reason for that is it doesn't exist. There was no representation made. There was no false representation. There was no representation relied upon. Now, what they seem to be saying or doing is to say, well, Waite Capital Inc. was undercapitalized. And they seem to say that because of this tax forfeiture. Now, Your Honor, I'm sure you know, tax forfeitures happen all the time because people don't timely pay their franchise taxes. That means nothing with respect to their capitalization. And there is not a shred of evidence related to the capitalization of Waite Capital Inc. But more important, there is not even an argument that Daniel Waite individually made any representation related to the capitalization of Waite Capital Inc. I don't see any evidence or even attempt to point to evidence of the alleged fraud, and I think you have to grant summary judgment on that ground, Your Honor.
Response?
Yes, Your Honor. So the fraud committed by Daniel Waite is the setting up this straw man that is Waite Capital Inc. And the badges of fraud are that it's clearly simply set up to take on whatever debts that they needed and then to tank the company. Daniel Waite is the only signatory of all their checks.
I'm going to grant summary judgment on this at this point. This is obviously interlocutory, and so I feel like you need to conduct more discovery if you're going to try to pursue that claim. That is not going to be enough, and so on the issue of fraud, I'm granting summary judgment. Again, it's interlocutory. I don't anticipate filing, agreeing to sever any of this out. So just to summarize, I want you to put together an order, Mr. Albert. I've denied summary judgment as to Wade individually on the breach of contract, American Construction, and Health Co. I've denied summary judgment. So I've granted summary judgment on, I'm sorry. I've denied summary judgment on those, granted summary judgment on Wyatt Capital LLC, and for the fraud claim on Wade. Does that cover all the claims?
I believe so. Just to be clear, Your Honor, there's no breach of contract claims. It's all alter ego and unjust enrichment. So if I'm understanding you,
yeah, I'm sorry that I misspoke for all the non-fraud claims.
Sure, understood, Your Honor, and I think that does cover it.
Okay, so I want you to say on the order at the beginning that this was heard on March 20th, 2023. That you share a copy of the order with Mr. Hoffman. I want the order emailed to my coordinator, Rhonda, at eFiled no later than this Friday morning. And do you guys have any questions?
Got it, Your Honor.
No, Your Honor.
Time.
Thank you.
All right, guys. Thank you so much. You have a great rest of your day.
You as well.
Thanks.
Thank you.
Thank you.